Imagine preparing for your own legal defense, carefully crafting cross-examination questions to challenge the prosecution's case, only to have those very questions fall into the hands of the prosecutor before trial. This is a concern facing me because I've been denied a public defender and I'm representing myself in court. If I'm arrested on a bench warrant while carrying my written cross-examination questions, police could seize them, and there's nothing stopping them from sharing those notes with the prosecutor. How can I get a fair trial if the state gets an advance look at my defense strategy? This raises a troubling issue. Does the justice system provide equal protection to those who cannot afford an attorney? The Sixth Amendment guarantees the right to legal representation, but when a defendant is forced to represent themselves and their only trial preparation is at risk of being compromised, it calls into question whether the system truly ensures due process. Legal protections exist for attorney work product, but for pro se defendants, those forced to defend themselves without legal counsel, there are fewer safeguards. If an arrest leads to police seizing written legal materials, what prevents the prosecution from gaining an unfair advantage? Should judges take steps to protect self-represented defendants from this risk? These are questions that demand public scrutiny. If courts fail to address this issue, it could mean that justice is not just unequal, it's deliberately stacked against those who can't afford to pay for it. And in my situation, I am facing an arrest warrant, a bench warrant, and I have cross-examination questions written out because Judge Barber doesn't allow electronics in the courtroom, so I have them written out on paper, and I need them to come with me. Okay, if I get arrested and transported, I need these, and I got several folders. I need these to be brought, but that means that my work product can be viewed by the cops and shared with the prosecutor, and I don't know how I can get protection from the prosecutor seeing it. It compromises my case. All right, I'm at a loss for security, being denied a free lawyer, facing an arrest warrant, denied using electronics in the courtroom. Judge Barber is stacked so much against me for proper defense. I mean, and there's other stuff as well. But by the way they're handling this whole thing, and this is just something else that I've realized is a problem with the prosecutor seeing it. But if it was Judge Owsley will say the door swings both ways anyway with discovery evidence. And he'll probably say that with cross-examination questions as well. Everything needs to be disclosed, right? This is such an unfair state. The people, the way they're trained, is their training apparently, and their privileges. They only privilege each other, but I have no privilege for a secure defense, and Judge Owsley says that everything I got should be allowed. The prosecutor should be allowed to see as well, which totally hamstrings a defense. And I'm gonna guess, because they have no problem putting out an arrest warrant for me and putting me on the NCIC, they have no problem with the prosecutor even seeing my cross-examination questions as well. That's the way it's looking.